Good morning, everyone. Can you all hear me there at the jail? Yes, ma'am. All right. Good morning. My name is Judge Christy Ruppe. You're all here this morning for first appearance. The purpose of this hearing is to inform you of the charges against you and determine whether there is probable cause for your arrest. Probable cause only means that it's more likely than not that you committed the crime in which you've been arrested for. As you stand before me today, you are considered not guilty, and that status will stay with you through each stage of these proceedings up until changed by you if you plead out to your case or the state attorney's office if they prove the case against you. In all likelihood, you are arrested on a warrant or a new charge, and either way given a bond pursuant to the bond schedule for the 5th Judicial Circuit. I will determine whether to keep that bond the same, increase it, decrease it, or whether there are any other conditions of pretrial release which will be imposed upon you. You are entitled to have an attorney represent you at each stage of these proceedings. I will determine this morning whether you're going to hire a private attorney or whether you want the assistance of the Public Defender's Office to represent you. You're also entitled to make a phone call. If you haven't done so yet, please let me know. I'll make sure that happens today. Finally, you have the right to remain silent, and I encourage you to do so. Please don't say anything about the facts of your case today. These hearings are recorded. There's an assistant state attorney in this courtroom writing down anything that you do say. So anything you say about the facts of your case can and will be used against you in the prosecution of your case. At this time, I'd like everyone to raise your right hand so I can place you under oath. Swear from the testimony before the court will be the truth, whole truth, and nothing but the truth. Okay, go ahead and put your hands down. As I call your case, please come. As I call your name, please come to the podium. Nicholas Courtwright. And Mr. Courtwright, what's your date of birth?
12/25/78, ma'am.
Okay. You are here this morning on a warrant signed by Judge Eineman for possession of marijuana and possession of paraphernalia. I have had the opportunity to review the warrant, the probable cause affidavit, in this case. I did find probable cause for the possession of marijuana, and even though it was on a warrant signed by Judge Eineman, I don't find probable cause for the possession of paraphernalia because there is no test done on the narcotic equipment. Do you want to represent yourself on these things? You're going to hire an attorney, or do you want the assistance of a public defender?
A public defender, please.
Unless
we can just be
done
with it. Unless there's somebody we can just be done with it today, or
I don't know. Let's find out. State receiver prior record.
Judge, he has burglary of a conveyance, about 4 charges that were guilty in 2014. He doesn't have much of a prior record. He has a lot of stuff out of state, out of Illinois back in like 2000, back in the 90s. Paraphernalia and drugs and doses.
Back in the 90s? Okay. And the 2014 case, was that an adjudication on that? Yeah.
Yes, adjudicated guilty.
Okay. Are you still on probation for something?
No, ma'am.
Okay. That 2014 case, how was that resolved?
I served time in prison for it, ma'am.
Okay. When did you get out?
November 14th.
2016?
Yes, ma'am.
Okay. All right. If you wanted to resolve these cases today, you would plead to both of these. Even though I don't find probable cause for the possession of paraphernalia, that doesn't mean that the state attorney is not going to prosecute that case. And it only means that the officer did not put in the probable cause affidavit the information that I need to find probable cause. It doesn't mean that the information is not there, so they'll update that information. If you wanted to plea out to both of these today, I'd go ahead and give you 90 days jail. Do you want to do that today?
No, ma'am.
Okay. All right, so we'll keep the bond on the possession of marijuana at $1,000.
Is there any way that could be dropped some? Because I'm a severe epileptic and I have to go to the doctor every week. I have seizures.
No, based on your prior record and the fact that you just got out of prison in November, I'm going to keep that at $1,000, but I don't find probable cause for count 2, so that's going to be an ROR. We're going to see you back to court on these cases on August 16th at 9 a.m. If you do bond out, you want to reach out to your public defender. If you're unable to bond out, someone will come out and see you, okay? Hector Diaz. Mr. Diaz, what's your date of birth?
3/28/57.
Okay, you were here this morning for a DUI. I did find probable cause for that. Do you want to represent yourself? Do you want to hire a private attorney, or would you like the assistance of the public defender's office?
I'll represent myself.
Okay. State to see your prior record?
Judge, I'm showing no record.
Okay. All right, Mr. Diaz, how long have you lived in, do you live in Sarasota?
Yes,
Okay, how long have you lived there?
since November.
Okay, do you have family or friends up here in Hernando?
No.
Okay, just driving through?
Yes.
Okay. All right, so you got a job?
Yes, ma'am.
What kind of work do you do?
I'm a supervisor for Home Depot.
Alrighty. Okay, well, you don't have a prior record, but you also don't have ties to the community, but you do have a pretty good job. So I'm going to go ahead and set your bond at $100. We're going to see you back to court on August 16th at 9 a.m., okay?
Okay.
Mark Haslam. Mr. Haslam, what's your date of birth?
4/13/92.
Okay, you are here this morning. Okay, the first case I have is a grand theft. I did find probable cause for that. Do you want to represent yourself? You're going to hire somebody? You want the public defender's office?
Public defender, please.
Okay, I'll provisionally appoint the public defender to represent you. We're going to see you back to court on that date on August 22nd at 9 a.m. And we're going to keep that bond at $2,000. Next case I have is fraudulent use of a credit card. I did find probable cause for that. I'll appoint the public defender to represent you. I'll set the bond at $2,000. And we're going to see you back to court on August 22nd. Third case I have is loitering and prowling. The bond on that is currently $500, and possession of drug paraphernalia. The bond on that is currently $1,000. I did find probable cause for the loitering and prowling, and we're going to keep that bond at $500. I'm just looking at the PC affidavit again because I don't think this is another one where there was nothing indicating that there was a narco test done on the needles. Okay, so there's no probable cause on count 2 on that for the possession of paraphernalia. So I'm going to ROR you on that. We're going to see you back to court on August 16th at 9 a.m. on that case. Okay, if you're unable to bond out, someone from the public defender's office will come out and see you, okay?
All right, thank you.
Okay. Eric Milady. Mr. Milady, what's your date of birth?
5/31/90.
Okay. You are here for a loitering and prowling. I did find probable cause. Do you want the public defender, or are you going to hire a private attorney?
Public defender.
Okay. Provisionally appoint the public defender to represent you. State to see for prior record.
2011 Hernando defrauding a pawnbroker that was guilty. He has a grand theft 2010 Hernando that was dropped. 2007 Hernando grand theft adjudication withheld. 2007 Hernando as well as petty theft guilty, and then he has some prior juvenile offenses, burglary, robbery back in 2006, but I don't have any disposition.
All right. Mr. Milady, you have a job?
Yes.
What kind of work do you do?
I work at Texas Roadhouse.
Okay. Here in Hernando?
Yes.
How long have you lived in Hernando?
27 years.
All right. Okay, I'm going to give you bond at $500. We'll see you back to court on August 16th at 9 a.m. Reach out to your public defender, okay?
Thank you.
Ismael Sanchez. And Mr. Sanchez, what's your date of birth?
10/26/81.
Okay. You are here this morning for a retail theft. The bond is currently $1,000, and an unlawful possession of personal identification. The bond on that is currently $1,000. I did find probable cause for both of these things. Do you want to represent yourself? Are you going to hire an attorney? Do you want the public defender's office?
Public Defender's Office.
Okay. State, does he have a prior record?
Judge, he's actually on probation on 17 MM 1394. So I think a law warrant should be forthcoming. He also has, it looks like he has out of state, New York, 2000 is the controlled substance, 2008 petty theft. I don't have any dispositions for those. 2013 looks like theft charges, all out of New York.
Okay. What was he on probation for, do we know?
Petty theft.
He was put on May 31st, 17.
Okay. Mr. Sanchez, you live on Elgin Boulevard?
Yes, I do.
Yes?
Yes.
Okay. How long have you lived there?
About 3 years.
Okay. You got a job these days?
Yes.
What kind of work do you do?
Maintenance at McDonald's.
Okay, step to the microphone. I can't hear you.
Maintenance at McDonald's.
Okay. Okay. When was the last time you worked?
A couple of days ago. Had the weekend off.
Yeah. What kind of money you make?
About $250 a week.
When was the last time you got paid?
About a week and a half ago.
Okay. All right, I've appointed the public defender on these charges. The bond on those is going to be $1,000 each. You're entitled to bond on those cases. However, you want to keep in mind that you're going to have a violation of probation coming up sometime, probably by the end of the week. So if you do bond out, you're just going to be rearrested on the violation of probation sometime in the next few days. So it might be a waste of money for you. We're going to see you back to court on this case on August 16th at 9 a.m. You also hear this morning Mr. Sanchez for a writ of bodily attachment for failure to pay child support. Based on your testimony before the court on your criminal case, I find that you failed to rebut the presumption that you have the ability to pay child support, that you are able-bodied, employed, and able to comply with the child support orders, that you are in willful contempt for failure to pay said child support, and that you have the present ability to pay the purge. The purge amount is $660. So you're either going to pay a purge or you're going to spend 10 days in jail. How much money do you think you can come up with in order to pay some of the purge?
No, nothing at the moment, Your Honor.
Well, you just got paid.
Yeah, I don't have any cash on me. I'm in jail.
Okay, well, you can have someone bring it down to the jail. How much can you come up with?
I can try, but my mother's on vacation, so
Yeah.
I have nobody in the county at the moment. If you wire me some money, then that's a different story, but I'm just telling you, the situation, Your Honor.
Okay, you have no intention of paying it. So I'm going to go ahead and sentence you to the 10 days Hernando County Jail. Or until you can pay $660. You might want to get in touch with the Department of Revenue and find out when your court date is for a child support hearing when you do get out of custody, okay?
Okay, Your Honor.
Robert Boswell.
Yes, Your Honor.
Mr. Boswell, what's your date of birth?
3 October 1960.
All right. You're here this morning for battery by strangulation. It's currently a no bond because it's domestic in nature. Also, a misdemeanor domestic battery is also no bond because it's domestic in nature. Pursuant to statute 741, you can't get a bond until you appear in front of a judge this morning. And then we also have possession of marijuana under 20 grams. Oh, no, that's not you. That is. And a possession of paraphernalia. The bond on those are currently $1,000 each. I did find probable cause for each of these. Do you want to represent yourself? You're going to hire somebody? You want the public defender's office?
Public Defender's Office, Your Honor.
I'll appoint the public defender to represent you. State.
I'm showing aggravated assault 2016 out of Jacksonville that was dropped. He also has possession of controlled substance and nuisance charges back in 2007 out of Jacksonville, carrying concealed firearm that was guilty out of Jacksonville, and then he has charges back in the 90s, DUIs, hit and runs, leaving the scene, resisting. That was like they were guilty as well.
Okay, Mr. Boswell, how long have you lived in Brooksville?
Since 95, Your Honor.
Okay, you got a job these days?
Yes, Your Honor. Painter, commercial painter and construction.
Okay. Okay, I'm going to set the bond at for the battery by strangulation at $20,000, the domestic battery at $10,000. As a condition of bond, I want you to have no contact with Brianna Boswell or Marcel Boswell. Those are your kids, right? No contact with them whatsoever. I'm going to hold you till 4 o'clock today in case your children want to file an injunction against you. The injunction is also going to say that you're to have no contact with them. Do not call, do not write, do not do email, do not do anything on social media. Do not have any third party call, write, or email them on your behalf. If you violate the order and you do have contact with either one of them, you will be charged with a new crime and held without bond until your cases are resolved. Do you understand?
Yes, sir, Your Honor. Your Honor, both my children are over the age of 21 and living at home.
Okay. We'll see you back to court August 22nd, 2017 at 9 a.m. on the felony cases. On the misdemeanor cases, we'll see you back to court August 16th at 9 a.m. Make sure to reach out to your public defender, okay?
Thank you.
Okay. Do we have a status check on somebody?
Yeah.
What was the name again? Raymond Downey. Is he there? Mr. Downey?
Yes, ma'am.
How you doing? All right. Looks like you're here for a status check on an extradition issue. Is it Oklahoma? Is that the state who wants you?
Yes, ma'am.
Okay. Oklahoma. Do we know, Joe, have they had any contact with Florida yet, indicating whether they want him or not?
I believe they do want him, but their communication status, they don't have teletypes there, so we're having to try to communicate with them by phone.
Okay. Did they give an indication of when they were going to come pick him up?
No, ma'am. We are still waiting, and they don't open until 9 o'clock this morning. They're an hour behind us.
Your Honor, their 15 days was up Friday at 12 o'clock.
Well, that's when we. Why are you saying their 15 days is up? Is that when you signed the extradition agreement?
According to Judge Turner, who took me into custody, he ordered they had 15 days, and if they did not respond within the 15 days, Friday at 12 o'clock p.m., that I was to be released. And today, I guess, is.
But it's not 15 days from when you were notified. It's 15 days from when they say they're going to come get you. And I don't know from the paperwork that I have today what day they were notified that you were here. It's 15 days from the date that they got notice, not 15 days from the date that you signed it. Do you understand? We can hold you up to 90 days according to the statute, waiting for them to decide whether they're going to come get you. But here's what I'm going to do. I'm going to involve the state attorney's office because they need to be involved. and they need to put something in writing to Oklahoma, the Oklahoma State Attorney's Office over there, because it's not only the Sheriff's Office that's responsible, it's also the State Attorney's Office, that they need to come and get you and pick you up and take you from our jail to their jail within 10 days. That's August 2nd. I'm going to give them until August 2nd to do that. Don't roll your eyes at me. Okay, we can hold you up to 90 days. I'm giving them 10 days. If they do not come get you within those 10 days, then they are to be notified that we will release him on the 10th day on August 2nd if they have not come and gotten him. And I understand you were under the impression that you had 15 days from the date that you signed it. That's not the case. You have up to 90 days, but 15 days from the day they say they're going to come get you. Okay?
Yes, ma'am, that's me.
Go ahead.
According to what the Judge Turner, I believe it was, is the name of him. He said that it was 15 days of not cutting weekends, I believe. He has a judge in order, in I guess in the courts or whatever. And he said as long as they didn't file anything or no contact was made, that I was to be released after the 15th day, ma'am.
Okay, I understand what you're saying, and I understand the impression that you were under, but that's just not the case, and that's not what I'm going to do here this morning. What I'm going to do is exactly what I said I'm going to do. The state attorney has written it down. She's going to go to her supervisors, and they're going to get in touch with someone from Oklahoma today, and we're going to figure out what's going on. If I can get you back here earlier, if Oklahoma gets back to them today and says that they're not going to come get you, then I'll have you called up from the jail today, and I will release you today. Okay, but I'm going to give them up to 10 days to figure out if they're going to come get you or not, or actually to come get you. Okay, if they don't do it by August 2nd, then you'll be released. If they decide before August 2nd, because it's not financially feasible for them to come get you, then we'll release you before that, okay?
Yes, ma'am.
Okay, thank you.
They talked to the assistant over there. He said the administrator who makes those decisions is until 9:30. And the only two people who think so is the sheriff and the administrator. So he's going to try to call back at 9:30.
Okay. Did we get everyone at the jail?
Yes, ma'am.
Okay, have a good day.